Prominent U.S. attorney and all-around good guy Robert Barnes, who does a weekly live stream with one of my friends here on YouTube, Viva Fry, that you should be watching, has come out with this pretty spicy tweet, and it's related to Marc Elias. So we're going to read the tweet, and then I'm going to show you what the drama behind the tweet is. This is a spicy one, especially if you care about the 2020 elections and the lawsuits that happened after it. Make sure to pay attention what's going on here. So, the Spygate money launderer, the Democratic hitman, the election fixer, famed corporate lawyer Marc Elias, sanctioned when caught lying to the court. Where is this on your docket at Democracy Docket? Okay, a couple things here. Marc Elias is the prominent Democrat attorney in most of the election lawsuits. He runs a website called Democracy Docket, which ostensibly listed all of the relevant legal actions that were happening in the wake of the 2020 election. But maybe there was some stuff missing from it. I don't know. Maybe some stuff took a little longer to post than others. Who knows? Who knows if that was going on or if that was intentional? He is also deeply involved in the Steele dossier and all sorts of other very fun things. But Marc Elias has just been caught lying to the court and has been sanctioned for it in a case going on right now. And I've actually got the document here thanks to Robert Barnes's tweet. And again, you should check out Robert Barnes on Twitter. He's got a great Twitter feed going, and his show with Viva Fry is second to none. So make sure you guys check it out. I'm going to link Viva Fry's channel where that show happens down in the description, along with Robert Barnes's Twitter account in case you want to follow along. Look, if you know who I am, you probably know who Robert Barnes is first, but make sure you check it out, okay? So this is from the Fifth Circuit Court of Appeals. This is the Texas area appeals court. And this is, of course, the Texas Alliance for Retired Americans, Sylvia Bruni, DSCC and DCCC versus Ruth Hughes in her official capacity as the Texas Secretary of State. Okay, so the background of this case is not super relevant, but basically Texas closed off some additional voting regulations, and the Democrats sued the state of Texas for what they called voter discrimination. And of course, you know what that means when a Democrat is accusing a Republican or a state of voter discrimination. What they really mean is the state made it harder to cheat and they don't like it. I'm sorry, there's really no other way to do it. I don't like wording it that way, but that is literally what it means today. It's not what it meant 30 and 40 years ago. Today, that's what it means, and it's pretty embarrassing. But let's take a quick look at what's going on. All right. It is further ordered that appellant's opposed motion to sanction appellee's counsel is granted. So the Secretary of State had a motion to sanction the lawyers for the Democrat Party, including Marc Elias. Appellees did not notify the court that their latest motion to supplement the record filed on February 10th, 2021 was nearly identical to the motion to supplement the record filed several months ago by the same attorneys on September 29th, 2020. So they're filing the same motion, and they have a duty to tell the court that it's basically the same thing that they're filing. Because if the court had made a particular determination before, the court would not want to waste time rehashing the same sorts of arguments unless there was something new and relevant to the supplement, okay? Critically, appellees likewise failed to notify the court their previous and nearly identical motion was denied. So it was denied before. They're trying to slip it in again several months later, hoping that the court doesn't realize what's going on. Unfortunately for them, you know, there's opposing counsel who's like, wait a minute, I saw this. They can't do this. And then they notified the court. This inexplicable failure to disclose the earlier denial of their motion violated their duty of candor to the court. Their duty of honesty, candor. They lied. They lied. Marc Elias. Moreover, to the extent that their motion, without directly saying so, sought reconsideration of their already denied motion. The motion was filed beyond the 14-day window for filing motions for reconsideration set forth in Federal Rule of Appellate Procedure 40A1 and Fifth Circuit Rules 27.2 and 40, and they did not seek permission to file out of time. So again, there is a process for them to say, hey, court, we disagree with your reasoning in denying our motion before. We're going to ask you to look at that again, considering this, this, and this. Thank you for doing that. That's a motion for reconsideration. They didn't do that. Instead, they just waited several months, hoping that the appeals court would not be paying attention, and just filed it again without saying anything. Appellee's only explanation for their redundant and misleading submission is that they construed the original denial of their motion to supplement the record as an order that applied only to the emergency stay proceedings. However, Appellee's original motion to supplement the record on appeal was not limited to the stay proceedings, nor was the order denying it so limited. There is no legal basis to support their post hoc contention that motions to supplement the record apply to only one stage of an appeal. So, if we can keep going here. This is a beatdown from the court. These are, you have to understand, these are lawyers for the Democrat Party. Marc Elias is one of the biggest election lawyers in the country right now. These are not novice lawyers. These are not people who are limited on resources and just happen to miss something or got a rule wrong. They knew exactly what they were doing, and the court here is taking them to task. If appellees had any confusion about the application of the order, they could have and should have disclosed the previously denied motion in their new motion. Moreover, after appellant notified appellees that they intended to file a motion for sanctions based on this lack of candor and violation of local rules, appellees could have withdrawn their motion. But they did not. Instead, they stood by a motion that multiplied the proceedings unreasonably and vexatiously. And why does this matter? Well, because there are two sides, and you can't have a motion. If you file a motion before the court, the other side basically has to respond. They have to expend time, resources, and most importantly, you got to pony up that cash to pay the lawyers to respond. And these are expensive lawsuits with big things going on. I mean, one motion, even just a motion to supplement the record, if it's opposed by the other party, it could be tens of thousands of dollars in costs to do so. So what's the punishment here? Sanctions are warranted in this case to deter future violations. The attorneys listed on the February 10th motion to supplement the record shall pay the reasonable attorney's fees and court costs incurred by appellant with respect to appellee's duplicative February 10th motion to be determined by this court following the filing of an affidavit by appellant and any response by appellees, and double costs. So now the Secretary of State is going to lay out how much it costs to fight against this thing in a motion. The Marc Elias' team will have to file back on that and say, hey, we agree or disagree with the number, and then they've got to pay double that. They've got to pay double it. Is this a massive, multi-million-dollar award? No, but it is a pretty big slap against the attorneys. It makes them look very bad. And of course, this is the Democrat election attorney lying to the court in an election case. Wonder where else it happened. Don't you? Don't you? And the court has one final thing here. The attorneys listed on the motion are also encouraged, albeit not required, to review Rule 3.3 of the Model Rules of Professional Conduct and complete 1 hour of continuing legal education in the area of ethics and professionalism, specifically candor with the court. That's the court being dad right there and saying, I'm really disappointed in you and your bad actions here. You could have done a lot better. You're going to have to work on this in the future. They're not required to do this, but putting it in there is a nasty little barb back at them. And hey, look, if you're going to lie to the court, you got to deal with the consequences. And it's a good thing the Texas Secretary of State was looking out, and their legal team was looking out for this and called him on it. They gave him the opportunity to withdraw, because you have a duty. If you find that the other party is not being truthful to the court, you as a lawyer have a duty to inform the court. But typically how you do it is what they did here. You send them a letter. You say, hey, we noticed this. Maybe it's a mix-up or whatever, but if you're going to make us respond to this, we're going to let the court know that this is duplicitous and it's wasteful and vexatious, and we're going to file for sanctions. So if you want to just go ahead and withdraw that thing that was already denied because you know it was wrong, why don't you go ahead and do that? Let's put this to rest. They didn't do it. So now they get slapped with sanctions, and that is what they deserve. But anyway, I forgot to mention, I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer and a legal political commentator here on YouTube. You already know this because you're watching the show. But if you're not subscribed, hit that subscribe button and the notification bell so you don't miss any future videos about legal news and political happenings. All right? And let me know what you think down in the comments below. Is Marc Elias a giant shyster, or is he just a little bit of a shyster? Look, he's a lawyer, so you know that that answer falls somewhere on that spectrum. All right, thank you for watching. Catch you next time. Peace. Peace.